Hello again. We're back. Thanks. Thanks for staying with us. So this is Federalism Part II, and we're talking about resolving those conflicts between the federal government and the state government, and it generally will occur on one of those four particular things. And what we find is that we've got state governments on one hand, we've got federal governments on the other hand, and sitting between them when all of these disputes are ongoing. Well, who do you think that might be? Of course, it's SCOTUS. So the Supreme Court determines where the balance of power lies at any given time. And it will be a function of one, generally, of these 4 points. So let's have a look at those. The Supremacy Clause says very simply that the Constitution and legitimate federal laws, highest form of law, and if state law conflicts with either of those, then the state law has to give way. And here's a few examples of those. Again, you can read, I imagine, so I'm going to let you read those. Any questions, do ping them to me afterwards. This is an interesting one. Remember that the Arizona versus US was a complicated case. There were 3 different questions. 2 of those went to the federal government. 1 of them went to the state government. I think the state government was to do with stop and search laws. There it goes. I actually say that. Ta-da! So there were 3 judgments. 2 of them went to the federal government. 1 of them went to the state government. So a complicated little piece. But anyway, have a read of that. Do ping me your questions. Much more interesting, really, are the implied powers in the elastic clause. And this says that Congress shall have power to make all laws, blah, blah, blah. Again, I'm rather presuming you can read. The key evidence here is the select law draft cases. This one here. This is your go-to example of the elastic clause. Now, this is to do with the right of the federal government to go around and hoover up able-bodied men, put them in a troop container, send them to a foreign field and have foreigners shoot at them. Obviously, there's nothing in the Constitution that allows the federal government to do that. However, the federal government is charged by the Constitution to maintain the army and navy and welfare and all that sort of stuff. And arguably, if in order to do this, they need to go around and draft people, conscript them into the army. Then how are they supposed to maintain an army when they're running out of people? I couldn't really have explained that any worse. I do apologize. But imagine it this way. If you are fighting a war, say, in France or Flanders, and the enemy just won't stop shooting your men, sooner or later you're going to run out of men. So you need to get more of them. Presumably by this point, people have worked out that going over to be shot at by Germans in Flanders is not a huge amount of fun, and so you have to force them to do that. That requires conscription laws. There's nothing in the Constitution about conscription laws. However, the Constitution does tell the federal government they have to maintain the army, and so that, arguably, certainly according to the Supreme Court, allowed them to impose conscription laws. I hope that's a little clearer. Again, I do apologize. Go to the OEA website and look that one up. Actually, it's not on the OEA website. You'll have to go somewhere else, probably Wikipedia for that one, but you'll be okay. Right. This is where it gets really, really, really interesting. And the Interstate Commerce Clause. Just a few words in the Constitution, but by crikey, this has generated a huge amount of controversy. And again, there are lots and lots of really, really good websites and podcasts that will help you make sense of this, not least the more perfect cases and by Radiolab. Also the what Trump can teach us about con law, and again that one Compass. Lots of very good, very good things. But the thing about the Interstate Commerce Clause is that the extent to which the federal government is allowed to use that to regulate stuff generally is going to be determined by the Supreme Court. And so in Hammer versus Dagenhart, which is to do with child labor, the Supreme Court said no, actually, the federal government does not have the right to tell states what to do, even if they are using children in their factories. And so they found for the states. This is what that arrow means. That means states win. Oh, hurrah. So you can use children in your factories. Wickard versus Philbin, however, was to do with not buying wheat. And on this occasion, they found for the government. So a big win for the feds there. If you're not buying wheat, then according to judges at the time of the New Deal, the government does have the right to regulate you and force you to buy wheat. Katzenberg versus McClung. This is to do with desegregation of restaurants in Alabama, I think it was. And again, thank you very much. and again, finding for the federal government. But after that, things start to turn against the federal government. 1995, we see the Gun-Free Zone Schools Act overturned. And then in US versus Morrison, we see the Violence Against Women Act overturned. Now, both of these laws should probably have not been passed using the Interstate Commerce Clause, but they did. The federal government justified that legislation under the Interstate Commerce Clause, but the Supreme Court decided, no, you've pushed it too far, chaps, and they overturned that legislation. Gonzalez versus Reich, it was about drugs, and on that occasion, the Supreme Court said, yep, absolutely, you are dealing with interstate commerce there. If California deregulates its marijuana market, then, or decriminalizes its marijuana market, then that is going to have an interstate implication. But then again, with the National Federation of Independent Businesses versus Sebelius, this is Obamacare. Obviously, in this case, the federal government did succeed in having its legislation upheld. But critically, when the Supreme Court delivered its verdict, they said, we are not upholding this on the grounds of the Interstate Commerce Clause. The Interstate Commerce Clause does not give the government the right to go and impose Obamacare. Instead, they said it under a separate judgment to do with the General Taxation Clause. But when it came to the Interstate Commerce Clause, the Supreme Court went out of its way to make it clear that though they were upholding this legislation, they were not doing it on the grounds of the Interstate Commerce Clause. So you can see here how the outcome of these cases, how the range of the Interstate Commerce Clause is essentially determined by the Supreme Court. Here, the Supreme Court looks at child labor and says, yeah, fine. Here, the Supreme Court looks at whether or not you cannot buy wheat, and they say, no, you can't do that. This one was about deregulation, desegregation of restaurants, guns, so that one's guns. This one, violence against women. This one, drugs, and this one, obviously, Obamacare. In each of these instances, the ability of the federal government to impose its will by virtue of the Interstate Commerce Clause comes under the jurisdiction of the Supreme Court, and they decide whether or not federal authority can be stretched to accommodate whatever it is that the federal government wants to do. This is very, very complicated, and in a 15-minute video, I'm probably not going to be able to demonstrate it adequately. What I'll do is I'll make sure I link off to the really, really strong podcasts that will help you get your head around the Interstate Commerce Clause, because this really is massively important. The other real source of constitutional conflict is to do with Due Process Equal Protection Clause. And this brings into conflict police powers and the Constitution. Now, you will remember that where that whereof the Constitution is silent, the states may speak. A lot of that gets tangled up with the police powers, and these are the things that the Constitution doesn't say. And again, this is explained extraordinarily well in a crash course. So I will link off to that in the comments, so do follow that one up. But essentially, the police powers grant states significant autonomy when it comes to shaping what their society actually looks like. Remember, there's nothing in the Constitution that determines all of these things, and so the powers that be, or rather defers back to the states. Now, that's all well and good, except when it runs into contact with the 14th Amendment, because the 14th Amendment, which can broadly be considered, their version, the Americans' version of the rule of law, this says that all laws apply to all people at all times and all in the same way. Now, if you're establishing a civil society where some things are legal and other things are illegal, or some people can do some things and other people can't do the same things, then you're going to run into trouble when it comes to the 14th Amendment. And this is what we've seen. So here we have Plessy versus Ferguson, which we talked about. That's to do with segregation. Brown versus Topeka Board of Education, that's segregation again. Lawrence versus Texas, now we're talking about gay rights. Obergefell versus Hodges, gay rights again. Baker versus Carr is to do with representation through elections, as is Crawford County and as is Shelby County. And in each of these instances, we see the Supreme Court deciding what can happen. So in Plessy versus Ferguson, the Supreme Court says for the states, yes, you can have separate but equal facilities. Brown versus Topeka Board of Education, the Supreme Court changes its mind. No, separate is not equal. That can't be done. Lawrence versus Texas, this overturned the previous judgment of Bowers versus Hardwick from 1986, where they said that gay sex could not be criminalized. Obergefell versus Hodges, this was to do with gay marriage. All states now had to recognize gay marriage. And Baker versus Carr was to do with redistricting and the thorny issue of gerrymandering. In that instance, the federal government won, and they were able to impose a shape and structure on redistricting. Crawford County and Shelby County, on the other hand, in both of those instances, we see the Supreme Court finding for the state and state election laws. So again, we see the Supreme Court changing its position in various areas. And I don't want to get dragged into this right now, but obviously, certainly when you're looking at anything post-2000 and certainly 21st century, so that one, and that one, your key figure, sorry, that one, there we go, you need to think about what this means in terms of Justice Kennedy. Okay, so the 14th Amendment Due Process Clause, that asks the question, to what state or how far are you going to allow states to establish the shape of their own civil society, if perhaps what that is doing is in direct contradiction to what other states are doing, and indeed what the federal government thinks they should be doing. Should states be allowed to segregate? Should states be allowed to have prohibited laws against gay rights? Should states be allowed to manipulate the elections to suit the outcome? I'm getting a little bit political here and I'm rambling, so I'm going to move on. The critical point is this. It's all to do with power. The enumerated powers of the federal government, concurrent powers, as I said, are those shared between federal and state governments, and reserve powers are those that accrue finally to the states. But there is flexibility in the model. The Interstate Commerce Clause, the Elastic Clause, the Supremacy Clause, and of course the Due Process Clause, which I should have in there, is due process. All of those allow for constitutional flex. And when you have constitutional flex, then it falls to the Supreme Court to decide how far and in which direction the Constitution should flex. Okay, I've got about 3 minutes left. So very, very quickly, dual federalism, cooperative federalism, new federalism, post-new federalism. Dual federalism we established was the layer cake. Cooperative federalism is much more messy. You should really just, I think, have a look through this. The point is that when the proverbial hits the fan, it's very, very difficult for states to deal with that by themselves. And so the federal government really needs to come in. I think perhaps this deserves its own presentation. So I'm just going to leave that where it is right now. You can look at these. I will come back and I will explore them in a separate presentation, but that'll do right now. Okay, thanks for your attention. Send me your questions.